Judgment in the matter of the Secretary of State for the Environment, Food and Rural Affairs, Commissioners for His Majesty's Revenue and Customs, and Secretary of State for the Home Department against the Public and Commercial Services Union.
Lady Rose will explain this judgment.
This case is about when a trade union can sue an employer for breaking an employment contract between the employer and an individual employee, even though the trade union itself is not a party to that employment contract. According to Sections 1 subsection 1b and Section 1 subsection 3 of the Contracts, Rights of Third Parties Act 1999, if a contract term benefits a third party who is clearly named in the contract, that third party can enforce that term by suing the other party for breach of the term. But under Section 1 subsection 2, this does not apply if it is clear from the contract that the original parties did not intend for the third party to be able to enforce the term. This case raises an important question about how to interpret Section 1 subsection 2. The employers involved are 3 government departments. Some of their employees, who are the claimants in this case, are members of the Public and Commercial Services Union. The departments recognise the union for collective bargaining purposes. These employees had chosen for many years to have their union dues deducted directly from their salaries through the payroll system, and the employers would then pay those amounts over to the union. This system is called a check-off arrangement. The check-off arrangement was originally introduced following agreement between the government and the trade unions in the 1960s. In 2014 and 2015, the departments breached their contracts with their employees by unilaterally stopping the check-off arrangements, so employees had to find their own way to pay their union dues. The employees sued the departments for this breach, but the union was the one that really suffered because stopping the check-off arrangement caused a significant drop in their subscription income. So the union also sued the departments, claiming that it had the right to enforce the check-off terms in the employees' contracts as a third party under Section 1 of the 1999 Act. Both the employees and the union won their cases against the departments in the High Court. The departments appealed all 3 judgments, and the Court of Appeal heard the appeals together. The Court of Appeal agreed with the courts below that the departments were liable to the individual employees for breaching their contracts, but by a majority, the Court of Appeal rejected the union's claim under the 1999 Act. The majority said, applying Section 1 subsection 2, that the employer and the employees did not intend for the union to enforce the check-off arrangements. The main reason the Court of Appeal gave was that the check-off arrangements originally came from a collective bargaining agreement. Everyone understands that the old collective agreements concluded between the union and the employer many decades ago are not legally binding, so the union could not sue on those collective agreements in court. That is now because of Section 179 subsection 1b of the Trade Union and Labour Relations Consolidation Act. That requires collective agreements to explicitly state that they are legally enforceable before that can happen, and these agreements did not say that. The Court of Appeal thought that meant that the individual employees and the employers did not intend the union to have third-party rights to enforce the term via the individual employment contracts either. The union now appeals to the Supreme Court. The Supreme Court unanimously allows the appeal. The parties agree that the union is clearly identified as a third party in the individual employment contracts between each claimant and his or her employer, and the check-off term benefits the union. Those are 2 conditions set in the Act that have to be satisfied before a third party can enforce a contract between those 2 other people. Those conditions are satisfied. So if those criteria are met, the statute creates a strong presumption that a term benefiting a named third party is enforceable by that third party, and this presumption is the starting point under Section 1, subsection 2. So the union does not need to prove that the original parties positively intended the term to be enforceable by it. Instead, to overcome the presumption, it is up to the employer to show that both it and the employees positively intended the term not to be enforceable by the third party based on an objective interpretation of the contract. Under the 1999 Act, the Court first looks at the express terms of the contract. The Supreme Court holds that there is nothing expressly provided in the employment contracts to say that the union cannot enforce the check-off arrangements. Then the Court must consider whether any additional terms should be implied into the contract to effect this. There is a strict test for implying a term into a contract, and in this case, we hold that it is not clear that an objective observer would think that the parties intended that the union should not be able to enforce the check-off arrangement. In fact, given the circumstances when the contracts were made, it is more likely that everyone assumed the union would be able to enforce it. That is because employees generally rely on their union to fight their corner with the employer over matters which affect all employees in the workplace. That is actually what happened here too. The facts recorded by the High Court judges hearing the claims show that the union took the lead on behalf of the employees in arguing against the removal of the check-off arrangements, and the union supported individual employees who wanted to bring a claim against their employer. This also suggests that there was no implied term that the union cannot enforce the check-off arrangements. So the presumption that the union can enforce them stands. It is not right for the employers to argue that this result somehow involves the union getting round a ban on the legal enforceability of collective agreements and enforcing those agreements through the back door. Section 179 of TULCRA does not contain a policy that unions should not have legally enforceable rights. Even with collective agreements, it depends on what the parties intended. The Court of Appeal was also influenced by the fact that the employees could pay lots of different organisations through check-off arrangements, as well as the union. These included paying their subs to social clubs or charities, or to cover insurance premiums or pension contributions. Surely, the Court of Appeal said, they did not all get third-party rights. The Supreme Court holds that it is not relevant to consider how other organisations might benefit from check-off arrangements in the employment contracts. Those cases might involve different issues than those involved in the union deducting its dues, since each organisation has a different role from the trade union. Lord Burrows gives a judgment agreeing with Lord Sales and me. He believes that the context of collective bargaining is part of the background that can help interpret the clear terms of the individual employment contracts, including the check-off terms. This background also helps decide if any terms should be implied. Considering this, the statutory presumption has not been overturned. There is no contradiction between saying on the one hand that a collective agreement isn't enforceable between an employer and a union, and on the other hand, allowing a union to enforce a term against the employer under an employment contract because of the 1999 Act.
The Court is now adjourned.